Thank you, Isaac. Please be advised that nothing in my speech should be taken as a legal advice, and for your individual case, please contact your lawyer. The reality of startup currently that everyone is concentrated on the success, but not thinking about potential problem, which can go with a great success. So first, it's never too early to incorporate your legal entity, which can prevent future problems, as well as the problems with your founding team, the core team, which was from the beginning. And then after some time, the team drove up and you have the new people in your team and you're growing your startup together. And then the previous founders can claim that nothing would be happened without their investment, their time and energy in your startup from the beginning. So if you will have if you will incorporate your legal entity, you will have the founder agreement and you will know what is the responsibility each of you has. Then you will not have the problem, for example, which is a Facebook had when they had a lawsuit with the Winklevoss brothers and the company lost a lot of money. So please be careful with your incorporation of your legal entity. It also can prevent the problem with taxation, or as we lawyers sometimes say, the cheap stocks. So you will have the fair price on your equity when you will raise the money from the next rounds of your investments. Also, like when you are choosing your the country for your legal entity, it should meet your business purpose and also be like friendly for your business jurisdiction. You can compare advantages and disadvantages of such jurisdiction based on the taxation system, legal liability, cost of formation, and operational costs. Then the sum jurisdiction is also can provide the licenses which is necessary for you to operate. You should remember that operation without license, it can cause you a lot of troubles. It can be lawsuit from your customers, and also it can be the fee and the penalties, and also be arrested. Depends of like what is your business idea and how you're working on it. So I would hardly recommend to think about the licenses even before incorporation your legal entity, because it also has an impact on the changing or choosing the jurisdiction where you're going to grow and be the biggest corporation ever, right? So let's talk a little bit more about the founder agreement and what you can and cannot put in this. The founder agreement is clarifying the ownership of each member along with their duties toward organization must be framed right at the beginning. It must also contain the possibility of exit from the business of your founders, of one of the founders. Don't forget about vesting. Vesting protects the member of the founding team who take company forward and growing as in a corporation. If the people who was in the first team and they're like delivery something which they are agree on, then it's fine. Their shares will be vest. But if they're decided to drop off, and it can also cause the huge damage on the company, then you can just give the shares to the new people who is coming to your company and who will help you to build the company and the way it should be and on the first place. Don't forget also that it's very important when you are building your team to have the right employee agreement, because your relationship with your employee can cause you a lot of benefits and a lot of troubles in the same time. So this document must contain the terms of condition of your employment and clarify what exactly this individual duties and comprehensive being paid for their work. As well, in this employee agreement, you can add that, and you should do that obviously, then that during the person was working in your company, everything with this person was developed, all ideas with the person was generated, it's belonged to the company, not to this individual, because this individual was the company employee and get paid for being the part of the company. So all intellectual property right, which has a connection to the business of the company, should definitely belong to the company. Also, what I would suggest you accept your employee agreement, and you also can add like non-disclosure part to your employee agreement, but I would suggest to have the separate document about the confidentiality and assignment agreement for the employee. This can, on the first place, keep your prevent your employee for like running around and spreading your trading secret, or your maybe client database, or your core code, or whatever you are working on. And then also the second one, it will the second part will prevent him, either he's an employee or he already quit your company, but will prevent the actions to create the other company, which will be the direct or non-direct competitor of your business. And then having the old trading secrets, it will be easy for your employee to not get the same trouble that you had, and you basically pay for this experience. But let's stop also a little bit on non-disclosure agreement, not for your employee, but for the third party. Because the startup, like during the whole existence, has a different stages of the raising money and attract investors. And what to do if you are in a seed round of investments and you didn't fill up the patent, or for some reasons in your jurisdiction and in your particular case, you cannot have the patent. Then I would suggest, of course, the non-disclosure agreement can really help you, but also you should do some homework before sending the sensitive information according to your idea and your plan of this realization. Such as you should do the research about the company whom you're going to sell, and then check the company reputation on the market. Is the company did had a lawsuit or something similar before in the previous experience? Is it a trustable company, and do you actually work with that? It's, let's say, the short due diligence or on your new investors or your counterparty. As well, I would suggest you accept that like you are signing the non-disclosure agreement. Do not do that too long. Don't put unnecessary stuff in your non-disclosure agreement, because for the people who is actually reading it, and like you have just a lot of text which is not relevant for the information which you are going to share with your counterparty or with your investors, it will just make the process of negotiation longer. And then also, like if you're sending your business plan, or you I would suggest to put the mark that this business plan is strictly confidential. It will not protect you in the same way that the patent, or in the same way the non-disclosure agreement, but it depends on the country where you incorporated. In US and some states it can be very helpful, as same as in Europe. So pay attention on that as well. Also, what I want to talk according to like this line, you should protect your intellectual property rights. This is very important. You have a genius idea, this idea is perfect, and then like somebody just copying your idea and making the same, right? Or you can say that idea sometimes is flying in the air, and some people can came with the same idea at the same time. So don't forget that you should pay attention on the moment when you should start your patent. Patent give its inventor the right to prevent someone from making the same or using the idea or on their product. The copyright, for example, protecting the original works and original ideas of the author. Let's say that you already have your copyright on your idea, and then you want to create some other thing on the top of this idea. So only you have the right to do that if in the first place you do have the copyright on your idea. And then also trademarks protect the symbolic of the original work. the name, symbol, like the great example of the trademark, I would name Microsoft or IBM. It's also helped the recognition of your brand. It helps people to know that this is your product, you are the owner of this product, and maybe you have the whole line of the similar products, and they know that it's you. And if you have already made the reputation on the market as a reliable company, then all your product would be automatically like more attractive to your potential clients. And also there is a trading secret. The trade secret rights allow the owner to take actions against anyone who want to use these trade secrets on their benefits. It can be whatever. It can be even the recipe on a food or on a drinks like Coca-Cola or other brands, or it can be your clients list or your future expansion plans. So this is also very important. And you also should like sign the NDA like before you are actually going to share your trade secrets like separately and additionally. And then when you are eventually choosing your name, and then you will go with a trademark on this name and etc., you should check that this trademark is not belong to anyone and you will not have any problems in the future. You can start with a simple research like in a Google or in the website, which is the selling domain names. And then I would advise you to go to your IP lawyer and ask for the deeper analysis on this matter. And then in the future, you will not have like misunderstanding that there is two companies with the same name, or you cannot add, you cannot register your trademark. This can be like quite difficult. So pay attention on that as well. And I guess I will go with the questions, Isaac. If you have anyone, or we do have.
Yeah, cool. So we got.
Is the difference between the founders agreement and the typical shareholders agreement? Okay, so let's say that the founder is not always the investors, and sometimes founders is not investing their own money. They can invest their work, which is also cost money. It's in some kind of like, just let's say that you are taking a loan, right? So the person is working for free or almost for free for you, and they want to get their shares for their hard working, or a little bit like below the market price for the same employee, if it would be an employee. In the shareholder agreement, you can have your core team, your founders, as well as your investors who join you a little bit later. And then you have a different people. You have a founders, and you have a shareholders who is not the original founders of the idea, but they also can give you the work, like they can work for you, or they can give you value like investments or the contacts. It depends like what this shareholder particularly will do. I hope I answered on this question.
Yeah, thanks so much, Marina. I have some other questions that were asked here. So specifically, you spoke a little bit about kind of incorporation, thinking about where to incorporate, all the different questions that you want to ask yourselves as a company. So, you know, there's a lot of things changing in the space every week, every month. What are some of the, let's say, jurisdictions or regions that you think will be interesting for people to explore in 2020? And what are some of the reasons why they are changing or are new interesting things to explore?
Yeah, of course. The regulation definitely changing each day, and specifically on the cryptocurrency field, because it's in most of the countries it's still like in a sort of gray area. So it's not like totally prohibited to work with a cryptocurrency or use cryptocurrency as a payment from your clients, but it's still non-regulated, and mostly is not clear for your chief accountant officer even how to put your annual report if you have a lot of payments in a cryptocurrency, right? So I would suggest to pay attention on Singapore because of their update of the payment directive on February this year. and see what you can benefit from there. You can actually legally obtain the license and do the initial coin offering if you wish, or you can just have your internal coin for, let's say, an exchange, and etc. So it depends, like, what is your business model, what do you want to do with the cryptocurrency, because there is a lot of options what is possible to do. And also I would suggest to look at the trustable European jurisdiction like Switzerland or Liechtenstein, for example. And this also depends of what are you doing. But anyway, do your first primary research on this matter, and then definitely contact your lawyer.
Cool. So that's a great question or answer to lead into our follow-up from Bruja. Thank you. Which is, what would you say is a good jurisdiction to do an STO issuance and to do issue a payment token?
So if you're going to do STO, you should understand that it's not the token anymore, right? But it's your securities, which is just tokenized. So it's a digital form of your securities. And then you should follow the old security law, which is in that jurisdiction where you actually going to operate. Would it be like United States, or you can choose like MTF license in Liechtenstein, for example, and then you are having the rules in your business as your security exchange, basically. So legally, this is what has happened. You're trading the digital shares, or you're trading the digital bonds. Yeah,
cool.
I hope I answered on that one.
Yeah. Did you want to touch more on payment tokens?
Yeah, definitely. Like in Singapore, for example, with the last update of the payment directive, they classified what is the payment tokens. And then if you are obtaining the, let's say, SVF license in Singapore, like single purpose SVF license, you can also add the tokens in it, but exclusively payment tokens. It cannot be security, and also utilities highly depend on the country where it was issued, and it cannot match with the Singaporean regulation. But anyway, if you will get the legal opinion on the points on the payment tokens which you are supposedly going to trade on your platform, there should be no problems with that. So you are with, let's say, your payment institution, like European electronic money institution with the tokens inside, you can do that as well.
Very cool.
Of course, there is some requirements because of the fraud and the reputation of the cryptocurrency, but it's highly possible you can do that, definitely.
Very cool. And
I would say that some countries who was obtaining the license before, like the past 2 years, they are also making the regulations strict. Like here in Estonia, for example, the license for the wallet provider and an exchange license, which means that crypto exchange to the fiat money exchange, previously the process was super easy, and what you supposed to do is your IML rules should be clear and your onboarding of client procedure. Right now, they're also required the physical office, the physical employees here in Estonia. The weather is not always perfect, so not many companies want to move here, but it still kind of benefits for the companies to work like that. And then remember, if you have the license and you are regulated, you will have less problems with the banks and the opening the bank account. Because even if there is no regulation in a country and you are working with a cryptocurrency, so legally you are not breaking the law, but you will have troubles with the opening the bank account and explain to the bank what is the cryptocurrency doing in your platform and how you're working with that, how you're onboarding your clients. That's also an issue, can be. So bank accounts, think about that as well.
Yeah, so you've mentioned so many important different kind of keywords and or subjects that maybe not everyone's so familiar with. We talked about kind of keeping track of your IP, preparing for trademarking. So do you have a list of resources or recommended place for, let's say, someone or a startup that wants to cover these things, wants to do their initial research, where would you recommend? And maybe you can share some links in the chat with kind of where people can start to look into this and or maybe get in touch with you to find out more information.
Yeah, of course. Like first you should check on the website where you are actually buying your domain name. So if the domain name which you're like supposedly wanted to buy, it's kind of like occupied, and then you are like checking the different variation of that, is it like .com or .eu or something, then like you might see that most of them the sold, and then through the Google you can find the companies with a similar name. So if you have the name that the same, which is your competitors, or even not competitors, it can be just a different company which is selling the different stuff, but it can be confusing for your clients to find you and actually understand what exactly you are doing. If like all companies calls, let's say Microsoft, you know, there is a Microsoft food store, Microsoft, and then Microsoft Gym, it's still like super confusing. So I would like pay attention on like choosing the right name. It should be memorable and simple, that like will attract attention of your users. It's not necessary should describe what exactly your company doing, like let's say Uber example or the Wolt example. You will never know that the Uber is supposed to be a taxi and Wolt also taxi and the food delivery, right? Nothing says in their name that this is exactly what they're doing, but it's memorable and it's simple, which is like makes people to remember that faster than some more complicated names. And about the employee contract, yes, I want to add something, like try to make it more clear, right? So if you don't have the proper employee contract, and then your employee decided to leave the company with your customer list, with your idea, maybe with your core code, you don't have this agreement, he can easily create your like competitive or the other platform which is similar to your platform. So I would highly advise to start with a normal employee contract where it would says what the employee is doing for your company, and then also what how he get paid, and then actually the all intellectual property, his works or art or like whatever the business model of your company is belong to your company, not to your employee. This is will prevent this whole like situation when you have the competitor who is not doing the same mistake that your company did, only because this employee was in your company and already learned on all your mistakes. So if you have any other questions or maybe something wasn't clear, I would happy to answer you on it. Also be careful, guys, with spreading your ideas all around. This is what I said before about your non-disclosure agreement, not for your employees, but for the third parties.
So Isaac is just rejoining.
Yeah, you guys still doing the great job. It's almost not breaking and not interrupting. It's quite a good quality. So congratulations on that.
Thanks for that. And let me see if I find him here.
What is your real issue and what you need to pay attention on. And the second, this is the way how you're actually choosing your legal counselor. Is you get your answers. Did you get your answers in the way you can understand it and proceed with that in the future? Or maybe you should search more. This is also very important. And it's also never too early to get the counselor in-house, at least the part-time, to prevent the future problems in your company.
There you go.
Nope. Disappeared. Yeah. Oh yeah.
There is Isaac.
Hey, sorry about that. Thanks so much, Marina. Sorry, I missed the last 2 minutes and technical difficulties.
Yeah, I will repeat for you later on if you want.
Perfect. Awesome. Did you have anything final you wanted to say to everyone before we move over to Edward?
Well, I actually already give the
Perfect.
final advice. Yeah.
Perfect. Thank you. Thank you so much. And yeah, if you want to add contact details to the chat, I'm sure people have some follow-ups they'd love to be able to get in touch with you.
Definitely.
Thanks so much.
Thank you.